A very good morning to all my dear students. Today we are going to discuss about the drafting of an application under section 125 CRPC under the subject captioned as drafting, pleading and convincing. My dear students, before starting with the same, I just want to recapitulate the law relating to the grant of maintenance by the court of law and its relevance thereof. So let's start with the definition of maintenance. As you all are aware that the word maintenance has not been defined under the CRPC. As you are all aware that section 2 of the CRPC defines certain definitions or expressions such as cognizable offense, non-cognizable offense, etc. but does not define the word maintenance. As per the definitions given under the various law lexicon or the law dictionaries, maintenance may be defined as an amount payable by the husband to his wife who is unable to maintain herself either during the subsistence of the marriage or upon separation of marriage. Now there are various laws governing the maintenance. These laws are Hindu Marriage Act, Hindu Adoption and Maintenance Act, Muslim Women Protection of Right on Divorce Act 1986. For Parsis, there is a Parsi Marriage and Divorce Act 1936, and for Christians, Divorce Act 1869 is there. As far as the secular law with regard to the law of maintenance is concerned, the same has been laid down under the Code of Criminal Procedure. The relevant sections pertaining to the same are given under section 125 to 128 CRPC. As far as the provisions of temporary maintenance are concerned, they are laid down under section 24 of the Hindu Marriage Act and as well as under section 125 CRPC. Furthermore, section 36 of the Special Marriage Act also makes provisions for the wife to seek expenses from the husband if it appears to the district court that she does not have independent income sufficient for her support and the necessary expenses of the proceedings under Chapter 5 or Chapter 6 of that particular law or particular statute. As far as the permanent maintenance is concerned, it is the maintenance granted permanently after the disposal of the proceedings for divorce or separation. And the relevant applications can be filed under section 25 of the Hindu Marriage Act as well as section 18 of Hindu Adoption and Maintenance Act. As far as section 125 CRPC is concerned, this section provides for maintenance not only to the wife but also to the child and parents. Court may order a husband who has sufficient means but neglects or refuses to maintain his wife who is unable to maintain herself to provide monthly maintenance to her. However, wife shall not be entitled to receive maintenance if she is living in adultery or refuses to live with her husband without any sufficient reasons or living separately with mutual consent. Meaning thereby, following are the essentials to be taken into consideration by a law student or by a lawyer while drafting an application under section 125 CRPC. And these are: number one, husband there must be one husband and wife. And secondly, husband has the sufficient means, but he has neglected or refuses to maintain his wife, and she is unable to maintain herself. So these are the circumstances to be put therein while drafting an application. Further, the application further also states that a wife shall not be entitled to receive maintenance if she is living in adultery or refuses to live with her husband without any sufficient reasons, or living separately with mutual consent. So these are the 7 points or 6 points, as the case may be, must be put or must be raised or must be avoided in the application for maintenance under section 125 CRPC. As far as you all are aware that the word wife under section 125 used under 125.1 and 125.4 CRPC is concerned, they are different in connotations. Section 125 clause 4 contemplates a married woman, while wife living separately from her husband with mutual consent does not mean wife who obtains divorce by mutual consent and lives separately. Therefore, cannot be denied maintenance on this ground. So we have to put into considerations the clauses under which we are seeking the maintenance. That is why there is a distinction made under section 125 clause 1 and 125 clause 4 CRPC. Now, one of the important questions which may be put up in the mind of a law student is with regard to whether an earning woman is entitled to maintenance. As far as the law on this point is concerned, this was so held in the case of Rosalie Jacob versus Jacob A. Chakra Makal, 1973, 1 SCC 840, wherein the Supreme Court has held that wife having a school of her own and possessing wetlands is in a better financial position than husband who is not doing well in his profession and has no land. Hence, it is unnecessary to pay any maintenance to the wife in this particular circumstance. What about the maintenance to the woman who is living in a live-in relationship? As far as the law point on this is concerned, the Supreme Court, in the case of Chand Munia versus Virendra Kumar Singh Kushwaha, 2011, 1 SSC, page number 141, held that or expressed its opinion that a broad interpretation of wife should include cases where a man and woman living together as husband and wife for a reasonably long period of time in relationship. A strict proof of marriage should not be a precondition for maintenance under section 125 so as to fulfill the true spirit and the essence of the beneficial provisions of maintenance. Recently, in the case of Lalita Topo versus State of Jharkhand, 2018 Supreme Court, wherein the Supreme Court has held that a woman who is living in a live-in relationship has an efficacious remedy to seek maintenance under the protection of women from domestic violence, even if it is assumed that she is not entitled to the same under section 125 CRPC. In fact, under the Domestic Violence Act, the victim would be entitled to more relief than what is contemplated under section 125 CRPC. So from these two judgments, we may infer that a woman who who is in live-in relationship with a man can also claim maintenance not only under the CRPC but also under the Domestic Violence Act. What about the Muslim woman? As far as the law is concerned, in the case of Shahabanu versus Shahabanu Begum, 1986 Supreme Court, wherein the Supreme Court has held that Section 125 CRPC is a secular in nature, and as such, it is equally applicable to Muslim women as well. But by virtue of the subsequent enactment by the legislature regarding the maintenance, it depends upon the mutual consent of both the parties, meaning thereby, if both the parties agree to file an application before the concerned judicial magistrate and claiming maintenance under Section 125 CRPC, only then they are entitled to, only then she is entitled to claim maintenance under the secular law, that is CRPC. Otherwise, the wife would have to resort to the remedies as laid down under that particular law. So with this background, my dear students, we have just recapitulated the law relating to maintenance, and which would be more beneficial for us to make or to draft an application for maintenance under Section 125 CRPC. Now let's start with the same. As you all are aware that under Section 125 CRPC, previously the law was that the application for the same has to be filed before the judicial magistrate first class. Now, by virtue of enactment of Family Court Act 1984, and which came into force in the year 2018 or 19, as the case may be, the jurisdiction for filing an application under Section 125 are now vested with the principal judge of the family court. As such, the application needs to be filed before the principal judge family court. Secondly, it's not an IA, but an MA. MA means miscellaneous application number, which is to be filed in a criminal complaint number so-and-so of so-and-so year. Next, thereafter you have to give the title or designation of the parties as such. In the matter of Shrimati Y, wife of, residence of, this is just only a format I am giving it to you. And thereafter, if there is any person or if there is any child to the out of that particular wedlock, then that child, if he is also claiming, then it has to be filed through his mother as the legal guardian. So there are two parties to be made herein. Number one, that is Y, that is the wife, and secondly, Mr. A, that is the son of Mrs. Y and Mr. X. So these are the complainants. And secondly, Mr. X would be the respondent. While you were preparing this application and giving the designation of the parties, please mention their son of or the residence of nomenclature along with their name, so that while issuing the notice to that application, the court would not again going through the complete file. They will go and they will go through the applications as such and give notice to the or issue notice to the other side. Thereafter, you have to give the title to the case. And the title to the present applications would be as application under section 125 CRPC for maintenance. Thereafter, you will put most respectfully show it. Thereafter, you have to give the introduction about the complainant as well as the accused or the respondent as the case may be. Here in this application, you have to, in the first paragraph, that whether the wife who is claiming the maintenance is a lawfully wedded wife, or is a woman, or is a person who is in living relationship with another person. So here you will put, or you will mention this particular aspect as that the present applications contend that, or that the present complainant contends that the respondent and the complainant got married dated so and so through Hindu rituals and ceremonies. Here you may put, or you may annex along with the application the marriage certificate to this particular effect. Second, that the parties above named through this wedding have a legitimate child, a minor of 12 years. So this is the introduction of both the wife as well as the child who is born out of the lawful wedlock of this particular marriage. Number 3, that the complainant and the respondent got married in Delhi and are within the jurisdiction and are living within the jurisdiction of this honorable court, meaning thereby you are apprising the court about that it has the territorial as well as the subject matter jurisdiction to try the present application. As you all are aware that if the court is not having the jurisdiction to try the suit, then it may tantamount to nullity in the eye of law. Secondly, that the complainant on so and so date got to know about the extramarital affair of the respondent through her friend C. So this is one of the reason on which the maintenance can be given or awarded by the court of law. Second, that the complainant, when confronted the respondent about his extramarital affair, the respondent agreed with the same and asked the respondent to leave the matrimonial house of the respondent. Thereafter, the complainant along with her son started living with her father in his house. So from these 3 paragraphs, we may infer that the wife who has left the home, it is not of her own, but due to the pressure or due to the pressure tactics from the husband as such, meaning thereby the complainant has approached the court with clean hands, and it is the husband who is the guilty party over here. Next. As I have already apprised you that the complainant must not have an independent source of income and she has to claim it from her husband. So the next paragraph would be that the complainant has no independent source of income and is living with her retired father and thus dependent upon him. Next, that the minor child of the complainant is presently in school and she cannot afford his fees and expenditure as she is dependent upon her retired father. And at the last, you may again apply to the court that the complainant are residing at Delhi. This honorable court, therefore, is competent to try this present case. And at the end, you have to pray before the court that it is most respectfully prayed before this honorable court to pass an order allowing maintenance to be provided to the complainant and her son of rupees so and so per month against the respondent, or the to pass the cost of the proceedings and the litigation expenses, meaning thereby you will not only claim the maintenance from the husband, but also claim the cost and the expenses of the litigation as well. And at the end, you may also put before the court that to pass any other order which this honorable court may deem fit in the facts, in the light of the facts and the circumstances of the present case. And at the end, you have to put the signatures of the complainant as well as his advocate, the complainant through counsel, so and so, and the date as well as the place of the signing of the application needs to be mentioned. So this is all about today's lecture. But before parting with today's lecture, I just want to apprise you with the new topic which I am going to take in my next lecture. My next lecture would be on drafting of compounding of an offences application by way of compromise under section 320 clause 1 CRPC. So as such, my dear students, I just want to request you to kindly go through the section, that is section 320 CRPC, before coming to the next class for the better understanding of that topic. Thank you very much. We'll meet you soon in my next lecture. Stay safe, stay healthy. Thank you once again.